All right. Happy 2026, everybody. I hope everyone had a relaxing and enjoyable holiday season. I'm Aaron Dunn, an attorney here in the litigation department at Beresford Booth. And today I'm going to be talking to you about an exciting topic, and that is high stakes litigation, excuse me, and the importance of proper preparation. Though not coined by him, I've used a phrase that my grandfather used when I was growing up all the time, and that's proper preparation prevents poor performance. It's a phrase that I think applies certainly in my day-to-day practice and certainly when it comes to high stakes litigation. So let's get into it. What is high stakes litigation? Well, I'm talking everybody when they get into a lawsuit, they think at least to some extent their case is a high stakes piece of litigation. And you're right to a certain extent. Every case is important, but when I'm talking about high stakes litigation, I'm talking about cases with real financial exposure to one or both sides. Maybe a win results in a financial windfall to one side, and a loss has devastating financial impacts to one side. I'm talking about cases where there's a real reputational risk to one or both parties. What I mean there is, maybe it's a case where if you lose, you're going to have devastating impacts in your community, in your business community. Is it going to prevent you from growing as a business? Is it going to prevent you from taking on new employees? Are you going to garner media attention as a result of the case? And I'm also talking about cases where, depending on the outcome, a business may not survive or bankruptcy becomes inevitable. So I'm talking about cases where there's low margin for error. Margin for error. There's a razor thin margin for error, and the stakes are on the line, and you need to achieve a successful outcome because otherwise you're going to have devastating financial, reputational, or other type of result that's not going to bode well for you in the days, weeks, months, years to come. So, how do you achieve a successful outcome in high stakes litigation? You don't do it by accident. And you often don't do it by being the loudest and most aggressive party, by purporting to be the smartest person in the room. I think that's often not a winning strategy in high stakes cases. So, what do you do to achieve a successful outcome? I think the key is proper preparation. And what do I mean by proper preparation? I think there's three main pillars to proper preparation, and that's discipline planning, strategic foresight, and attention to detail. So what do I mean by discipline planning? I mean, identify the issues, the strengths and weaknesses of your case before you file suit. And when I say identify the issues, I'm not talking about, I was wronged or the seller didn't disclose something or they were negligent, they breached the contract. You got to dig deeper. What are the actual real issues? What obligation did the other side have that they didn't comply with? What duty did the other side have that they breached? What specifically did the seller have an obligation to disclose that they did not disclose? What provision of the agreement was breached? You got to dig deeper than the overarching 30,000 foot, I was wronged. You got to identify those issues because that's going to inform what legal claims are viable as a result. You got to identify your strengths and weaknesses from the outset. Is the law clearly on our side? Is this a gray area? In order to prevail, are we going to have to make new law? You got to know that from the outset. And you got to know, based on the evidence that we have before we file suit, without the benefit of discovery, what is that evidence and is it helpful, harmful, neutral? What evidence may exist that we expect to receive in discovery? And is that evidence helpful, harmful, neutral? We have to do that analysis in order to inform our plan for the litigation. You also got to identify your key objectives. And what do I mean by that? It's easy to say, I want $1 million. I don't want to pay the other side a dime. But what are your true objectives in the case? Is it that you're part of a business and you want to leave the business? You think you were wronged and you want to get out, start your own thing, but you want protection in terms of liability on the back end. You want to leave on favorable terms with no potential liability in the future. Is it that you really want to sell your house, but before you do so, you got to resolve this boundary dispute or this easement issue? Is it you're a defendant and you have a claim made against you, and you know there are other potential claimants out there, so you really want to resolve this claim as quickly as possible, get confidentiality so you can fend off to the extent possible future claims. You got to identify those key objectives because that, again, is going to inform what plan you put in place, how quickly you want to resolve the case, when you want to get it into a settlement posture. Knowing what your key objectives are is imperative. Part of discipline planning is getting on the same page. Attorney and client got to be on the same page. High stakes litigation is difficult enough battling the other side. It's going to be time consuming, it's going to be expensive. The worst thing, one of the worst things anyway, that you can have is infighting at the same time, fighting the war on two different fronts. You got to get on the same page. You're in the same boat, rowing in the same direction. You know what the end goal is. And so once you put a plan in place, you can execute. So really discipline planning is avoiding reactive litigation. What that means is you have an idea of what's coming, you know what your goal is, and you know how you're going to attack the other side, how you're going to fend off defenses from the other side to achieve a successful outcome. You don't want to be on your heels, you want to be on your toes. Another piece of proper preparation is strategic foresight, being able to see into the future, anticipate what's going to happen, and plan accordingly. So, how do you have foresight into what's going to happen? Well, you got to self scout. What do I mean by self scout? This is a phrase borrowed from my sports background, where a team knows their personnel, knows where their strengths and weaknesses are better than the other side. Same thing in litigation. You know your case better than your opponent does. You know what your strengths are. You know what your weaknesses are. How do you capitalize on those strengths and how do you minimize your weaknesses? Once you self scout, you're going to have a pretty good idea of where you're likely to be attacked, what the other side is likely going to focus on. But without self scouting, you may not have that foresight and you may not be able to plan accordingly. So self scouting is imperative. I have witnesses and experts. What do I mean by that? You got to know who you're going to be able to rely on in the case, who you're going to need in the case to prove your claims, or as a defendant to defend against the claims being made against your client. You got to know who you're going to call as a witness. Maybe it's a case where you're a business and one of the witnesses is going to be a former employee who left on unfavorable terms. Well, what does that mean for the case? Does that mean we're really in a world of hurt? Does that mean that can be overcome? You have to think about who's going to be involved, who are going to be the key players. In terms of experts, you got to think who you're going to need. What type of expert am I going to need? How early should I retain them? Should I retain them early on to inform my discovery strategy? Should I retain this expert early on so the other side doesn't have the opportunity to potentially retain that expert? You got to have that foresight. Jurisdictional realities and venue considerations. This is very important. Are you going to be in federal court? Are you going to be in state court? If you're a plaintiff, do you want to be in federal court? Do you want to avoid federal court at all costs? Well, that's going to inform how you plead, who you sue. If you're in state court, what venues are proper? All things being equal, if you have two different venues that are both proper, which one gives you the better strategic advantage to achieve the outcome that you want? If you're on the defense side, you want it in federal court. Are there ways to remove it to federal court? You got to think about the jurisdiction that you're in, what the realities of that jurisdiction are, what venue you're in, what the jury pool is going to look like. This all goes into the analysis before you file suit, before you get involved in high stakes litigation. So what is strategic foresight? It's really always thinking several steps ahead. The task at hand is the task at hand, but if you don't think several steps ahead, you're not going to have a good game plan, because litigation's a long, long journey and there's going to be bumps in the road, and you got to think, okay, if this motion gets denied, is that the end of the world? No, we have a plan. We just need to depose X, Y, and Z individuals, and hopefully we'll be able to present a winning argument, whether that be at the mediation table or in front of the court or in front of the jury. You got to have attention to detail. How you do something is how you do everything. And when I'm talking about attention to detail, I'm talking about leaving no stone unturned. That means you don't skim, you read. If you skim an agreement that's at issue in the case, you may miss a provision that either establishes that your side is going to win or the other side is going to lose, or maybe there's an attorney's fee provision that you wouldn't have caught that increases the exposure for one or both sides. So you got to read, you got to be detail oriented, you got to listen carefully. Sometimes what is not said is more important than what is said. So sometimes when you're listening, talking to a client, attorney client conversation, are you making an unjustified logical leap? Are you saying, for example, in simple terms, I was wronged, there's a potential connection to the defendant, therefore the defendant's liable? There's a lot of gaps in that before we actually succeed on a claim, right? So we got to be sure that we're not taking those logical leaps. Similarly, if a client is telling you a story and you say, I heard you say X, but what I didn't hear was Y. The client says, I gave this, they gave me this information, that was it. Well, I didn't hear you say why they didn't give you that extra information. Was there a logical reason? You got to be an active listener. And then attention to detail requires attention to local court rules. What you don't want to do is get involved in a case, have a plan in place that we're going to file a motion for summary judgment in 4 months. We're going to give the other side 28 days. We're going to note the motion 28 days out, only to realize when you note the motion that the local venue requires that you give 50 days notice. You got to note the motion 50 days beforehand. You got to be attentive to those local court rules, or you can get caught with your pants down, which you don't want to have happen. So detail oriented is a must in the planning stage. So we've talked about all this planning. What's the point? And the point is to be able to get a plan in place to be able to execute. If you don't have a plan, you can't execute anything. Here's a not so subtle secret. Every party in litigation wants to win, but not every party wants to prepare to win. That can be the difference. So you need to get a plan in place, knowing your strengths and weaknesses, understanding how you're going to maximize those strengths, minimize those weaknesses, and achieve that successful outcome in the best, most efficient way possible. When you have a good plan, what would otherwise be a back to the drawing board occurrence can be a mere detour. What I mean by that is you have this great plan in place. We're going to do discovery. We're going to file this motion on this issue. The court's going to grant it, and that's going to make the other side come to the table. Well, what if the court doesn't grant that motion? Are you going to say, oh boy, we're back to the drawing board? Or do you have the plan in place? You have that contingency in place. You had the foresight to know that that's not a given that the court's going to grant that motion, or that witness is going to testify how you want them to. You got to have that foresight to know what your plan B, if you will, is. So proper preparation means preparing for the worst, but hoping for the best. You don't have to have these separate spreadsheets, plan A, plan B, plan C, but you do have to think about what may happen in the litigation to inform your plan and be able to alter your plan and roll with the punches, all the while maintaining the goal to achieve that successful outcome. Now, proper preparation not only allows you to get a good plan in place, but allows for more streamlined litigation. What do I mean by streamlined litigation? I really mean not reactive litigation. In order to do that, you've got to frame issues clearly and credibly from the outset. One of the easiest ways to lose credibility with the opponent, with the court, is to frame issues in a way that look good on paper, sound good on paper, but are not credible. Let me give you a hypothetical example. If you go in and say, it's a seller disclosure dispute, and you say, they didn't disclose anything, and they're liable for fraud, misrepresentation, Consumer Protection Act, the whole nine. When in reality, the real issue is whether the disclosures that were made were sufficient or were accurate. If you don't frame that issue credibly, you're going to have to go back, walk back your statements, amend your complaint, amend your pleadings, and you're going to lose credibility with everyone. By framing your issues clearly and credibly, you can also stay on message throughout the case, from the pleading stage all the way through resolution. You have consistent themes, consistent messaging. You're not trying to fit a square peg into a round hole. You're not having the moving goalpost type thing. You're always staying on message. This is my theme. This is what I'm trying to establish. These are the questions that I need to ask witnesses. This is what I need my expert to say. And it's consistent throughout the case. That is the sign of a well-prepared case that's high stakes. Streamlined litigation also means targeted discovery, not just discovery for discovery's sake. What do I mean by that? Well, if you're in a case in a business dispute, you certainly don't want to be asking the other side, what injuries did you suffer in the car accident? That would be taken from, that's boilerplate discovery taken from a different type of case and not targeted. Discovery is valuable, make it valuable. Maybe you're not going to get a smoking gun in discovery, but you're certainly not going to get the smoking gun in discovery if you don't ask the right questions. So you got to take the time, ask the right questions, knowing what your themes are, knowing what you need to establish, and that'll allow for more streamlined litigation. Streamlined litigation also means you're prepared for likely motions and arguments. You know the other side is probably going to rely on this case, and you've had the time to think about it. You know how you're going to distinguish that case, or you know what cases that you're going to rely upon to say that this other case is not directly on point as the other side purports it to be. You know you've done the self-scouting. You know where your weaknesses are, and you know how to attack those weaknesses and at the same time maximize your strengths. And you don't need the desperate attempts to settle. Settlement is not the sign that you failed. It's a litigation strategy. It's a reflection of the risks involved in the case. Use it as the strategy. It's not a desperate attempt. A well-prepared case, you know when the opportunities, the most likely opportunities are to settle. You know when mediation is likely to occur. And if the other side comes to you and says, let's negotiate before maybe you thought was realistic, great. If not, you know you're just plugging along because you have a plan in place. So what can happen if a party fails to prepare properly? What are some of those signs? Well, one of the easiest signs, or one of the most recognizable signs, is they fail to assert viable claims or defenses. So, for example, a party goes in and says the other side was negligent, but they didn't do the proper planning, didn't realize that they really actually have a good Consumer Protection Act claim that would allow for enhanced damages and attorney's fees. But because they didn't do the proper preparation, they omitted that claim. Or on the defense side, you skimmed documents, you didn't realize that you had a viable defense, and you have to, after the fact, try to amend your pleadings, potentially face a waiver argument. Another sign of an ill-prepared case is somebody's changing their theories throughout the case. They start with fraud, then they go to misrepresentation, then they're at Consumer Protection Act, then they're at breach of contract, when throughout the only real viable, potentially viable claim was breach of contract. You don't want the moving goalposts. You want to have that consistent theme, that consistent messaging from the pleading stage all the way through resolution. Another sign of an ill-prepared case is somebody fails to ask the right questions in discovery, fails to ask the right questions in depositions. They just do boilerplate. They just ask the questions they always ask in depositions. In high-stakes litigation, discovery is too valuable. If you're in a party deposition, that's your one opportunity, typically, to talk to the other side before trial. So you got to make it valuable. Another sign of an ill-prepared case is they hire the wrong expert. Maybe they needed a structural engineer, but instead they hired a general contractor, or they didn't hire an expert at all, not realizing that they really did need a forensic accountant. Hiring the wrong expert is a telltale sign that a case is ill prepared. Another sign that a case is ill prepared is you're always on your heels. You're reactive. You're not proactive. You're doing those 5-alarm fire drills, researching a case when a motion gets filed, scrambling to figure out who your witnesses are. You haven't gone through the steps that are necessary to figure out who you're going to need, what witnesses are going to be at issue, who's going to be the most important witness or the most important witnesses. You're always on your heels. And then the final sign of an ill-prepared case is you have those desperate attempts to settle. You haven't executed on your plan. You didn't have a plan to begin with, and you get 3 months before trial and realize you're not prepared, and you have to go to the other side and say, can we resolve this on any terms? Those are signs of ill-prepared cases, and that's certainly not the position you want to be in when it comes to high-stakes litigation. So, what are some of the signs that an attorney is prepared to handle high-stakes litigation? Well, it tells you what you need to hear, not necessarily what you want to hear. This involves identifying those issues, identifying the strengths and weaknesses, being able to have a full and frank conversation about what the risks are. There are risks in every case, no doubt about it. High stakes litigation, the risks can be extreme. Client needs to know that. They need to know where their weaknesses are. They need to know what type of risk they're getting themselves into to make an informed choice. And sometimes those conversations are hard. You got to tell a client that their case isn't as good as they think it is. But they need to know that beforehand rather than learn that 6 months in, hundreds of thousands of dollars later in litigation costs, expert fees, et cetera, and then still be facing a loss. So you definitely need to know what the realities are, even if they're not pretty. You need an attorney who's prepared to handle high stakes litigation, verifies what they're told with documentation if documentation is available. They don't. It's a trust but verify situation. So client says we made an agreement with the other side. Attorney says, do you have any documents to support that fact? Is this truly a he said she said situation? They follow up with documentation, gather the documentation that is available that may become discoverable, especially, and they need to know what's in there. Absent compelling circumstances, don't rush into litigation. I think this is an important one. There are times, no doubt, that you do have to rush into litigation, statute of limitations issues. There's something about to happen that you want to prevent, that you want to get an injunction. But most of the time, I'll say, as a general rule, in order to do the proper preparation, you're not going to rush into the courtroom. Maybe there are opportunities to resolve the case short of litigation. That would be high stakes litigation, but because you've prepared properly, you can go to the other side and say, let's get this resolved because it's not going to benefit anyone if we get into high stakes litigation, if we get into protracted litigation, and we're having this conversation 18 months from now. Another sign that an attorney is prepared to handle high stakes litigation is that they can convey difficult concepts in a simple manner. As attorneys, we're taught to speak legalese, we use Latin terms. Clients don't often understand what we're talking about or how it fits into the plan at play. So attorneys need to repackage information in a way that's digestible to the client, to lay people, to the judge, the jury, whoever they are presenting before, to make sure that the information gets conveyed that needs to get conveyed in a manner that can be understood. Similarly, if it's a highly technical case, maybe accounting intensive or engineering intensive, the attorney needs to be a quote unquote pseudo expert in that field, be able to speak the lingo with those individuals in that specialized field, but also convey it to lay people in a manner that makes sense. An attorney that's prepared to handle high stakes litigation is also able to win multiple ways. What do I mean by that? Well, another sports analogy, you hear good teams and they'll say, we were able to win multiple ways this year. We were able to win ugly. We were able to win high scoring games. We were able to win low scoring games. I think it's important in high stakes litigation that an attorney is able to win multiple ways because some cases are going to hinge on what the meaning of this word or this phrase is. It's going to be a brief writing case where you're going to submit your competing arguments to the court, and the court's going to decide a purely legal issue. Some cases are going to be purely factual. It's not susceptible to summary judgment or judgment before trial. It's going to hinge on who can marshal the evidence and be most persuasive before the judge or the jury. Some cases are going to be ugly. There's going to be discovery disputes. They're going to get drawn out. Can the attorney handle that? Some cases are only going to have two witnesses. Some cases are going to have 50. Being able to win multiple ways is important when it comes to high stakes litigation because no two cases are exactly alike. In fact, most cases are wildly different. And then the final sign that an attorney is prepared to handle high stakes litigation is they have an excellent support team around them. High stakes litigation is costly, time consuming. There's motions, there's correspondence, there's drafting. There's so much that goes into it that you need to have an excellent support team behind you. Fellow attorneys within the firm, support staff, from top to bottom, you got to be that unified ship rowing in the same direction, all striking on all cylinders. It takes a team effort. It truly does. One person does not determine the outcome of high stakes litigation. It truly does take a team. So what's kind of the moral of the story today? The moral of the story is failing to prepare. Failing to prepare is preparing to fail. When it comes to high stakes litigation, time and resources spent preparing is imperative. There's no substitute for it, and really no excuse for lack of it. If you want to get involved in high stakes litigation, you better bring your A game, and you better be prepared. Um, so, and like I said on the slide here, proper preparation can be the difference, often is the difference between a successful outcome and what sometimes can be a disastrous outcome. So even though it may feel to the client like you're spending a lot of time and money before a lawsuit's even filed, when it comes to high stakes litigation, it's often well worth it on the back end. So if you have high stakes litigation on the horizon or you're already in it, make sure you have the right team around you. That's going to be often the difference between a good result and a bad result. The attorneys here at Beresford Booth have plenty of experience handling a wide variety of litigation, and we really appreciate the opportunity to serve our clients. So if you have a question about litigation, want to chat with me, my information is on the screen. Thank you, everyone. Have a great start to 2026.